Hello, everyone. Welcome back to our Austin Startup Week work from home session. I am incredibly excited to introduce this next session. We have three attorneys joining us from Hush Blackwell here in Austin. And please introduce Albert Carrion, Kevin Koronka, and Sonia Ramirez Anderson. And they're going to be touching on some really important themes today. As we talk about this work and from home environment, it creates new issues around employment law and intellectual property. And so we've got three legal eagles here to help dig into that and share their expertise. Just by a billable hour alone, you're getting incredible value here during the session. So I'm going to turn it over to the Hush Blackwell team and let y'all take it away.
Thanks, Gavin. Hello, everyone. My name is Sonia Ramirez Anderson, and I will be the moderator for this panel presentation. Like Gavin said, we'll be talking with you today about employee classification, overtime pay, and benefits issues that software developers who work from home face. The panel will also analyze similar compliance issues concerning developers as independent contractors, and we will address intellectual property ownership issues in both contexts. I am a labor and employment associate in our Denver office of Hush Blackwell, and my practice basically consists of helping employers work through state and federal employment issues by advising employers on handbook issues, employee classification, and then if the litigation arises that involves employment issues, I step in and help out as well. Joining me today on the panel are Albert Carrion and Kevin Koronka, who are in our Austin office. Albert relies on his interdisciplinary skills as an intellectual property attorney and to guide clients to seeking to develop and protect their IP and those seeking to acquire or license IP to improve their business operations. He is an experienced trademark lawyer, and he helps clients select, register, and protect brands that identify and distinguish their products and services. Kevin is also an employment lawyer who guides his clients on a wide variety of HR issues, from best practices, high-level investigations, and sensitive terminations, among other things. Kevin's clients value his practical approach as he provides quick and concise answers that minimize legal risk and permit businesses to avoid becoming unnecessarily sidetracked with workforce issues. While he aims to help clients stay in front of problems, at times litigation is unavoidable. When clients do find themselves in court, Kevin is an aggressive advocate for their interest. If you have any questions during this webcast, please submit your questions via the question box. We have prepared some questions in advance to cover the scope of the presentation, and we'll try to answer questions submitted at the end. We truly appreciate audience participation and encourage you to please submit questions. Finally, please understand that the information presented in this presentation is intended for educational purposes only. You should not use this presentation as a rendering of any kind of legal advice for specific cases or instances. We are not your attorneys at this point. If you'd like to talk to us afterwards, feel free to email us. That information will be available at the end of the presentation. With that said, Kevin, the first question I have is for you. Are software developers entitled to paid overtime, and what factors are involved in determining this?
Yeah, thanks, Sonia, and thank everybody out there for being involved today. Like Sonia said, if you guys have questions, please feel free to ask them. We really want this to be an interactive session. So the short answer, I think, to your question, are software developers entitled to be paid overtime? Like most answers that you're going to hear from a lawyer, it depends on the circumstances, right? This is really an important issue for startups in the tech space who are hiring people to, write code, develop apps, develop software, because federal law requires overtime to be paid to employees who are not considered to be exempt under the Federal Fair Labor Standards Act. So there are a variety of different exemptions that may take an employee outside of the overtime requirements. But with regard to software developers, today we're really going to focus on what's called the computer employee exception under the Fair Labor Standards Act. The FLSA, I think, is a pretty difficult statute to understand, but my clients struggle, I think, more often than not with this computer employee exemption. What does it mean? Who qualifies for it? It's a really important issue, because if you get it wrong, if you classify somebody as exempt when they really should be non-exempt, you're going to end up in court with an employee filing a lawsuit against you, or the Department of Labor coming down and doing an audit or an investigation on your employee classifications. So those things are obviously very, very expensive, very time consuming, distracting. Those cases are hard to win. So it's important that you get it right on the front end. Really what it boils down to on whether somebody qualifies for this computer employee exemption, and as a software developer and not paying them overtime as an employee, you have to look at, one, their rate of pay. As long as you pay them above the minimum salary threshold for exempt employees, or for computer employees particularly, there's a certain hourly rate as well. But that level changed. The threshold changed on January 1st of this year. The salary threshold required to be exempt is now a little bit less than $36,000 a year, or $684 a week. Alternatively, like I said, if you're paying a software developer by the hour, there's a special rule there. If they're paid at least $27.63 an hour, they're going to meet that pay rate threshold to qualify as exempt. So I think most of you will find that software developers are going to meet that salary threshold or that hourly rate threshold pretty easily. So the second question, and the more complex question, is, assuming you're paying them enough, does the employee's primary duty involve work that would fall within the exemption? And under the FLSA, primary duty means the principal, the main, the major, the most important duty that an employee performs. Title by itself, just calling somebody a software developer, calling them a software engineer, that's not enough. It doesn't really matter what the title is. The Department of Labor bases these exemptions to overtime on specific job duties and the rate of pay, like I said. So, if they're being paid enough to be exempt, next step, look at primary duties. The computer employee exemption is really complicated, so I'd encourage you guys to Google computer employee exemption. Department of Labor has a big blurb on its website about it. But what it really boils down to is the employee involved in the application of systems analysis, techniques, procedures? Are they determining hardware, software, system functionality? Are they modifying, designing software, developing apps, prototypes, some combination of the two? The definitions are pretty exhaustive, so you want to go and look at it for yourself. But what the courts have come out and said is, when they're looking at this issue, they're focusing on an employee's primary duties. It must require theoretical or practical application or highly specialized knowledge in computer systems, programming, and software engineering. Not just highly specialized knowledge of computers, but highly specialized knowledge of programming, coding, software engineering. There's even a recent case out of Minnesota even goes as far as to say, writing computer code is critical to the analysis of this exemption. If your folks aren't involved in that sort of software development, if it's more manufacturing, repairing hardware, things like that, you're probably not going to qualify for the exemption. Examples of some jobs that don't qualify, like here at the law firm, we have folks that staff a help desk, and they know way more about computers than I'll ever know. But they're not software developers. They're not engineers. They're fixing problems. They're debugging things, installing workstations. Those sort of job duties don't really rise to the level of what the computer employee exemption is designed to accomplish. So just because somebody works in IT, that doesn't mean that she's automatically exempt from FLSA coverage. You guys also want to keep in mind that state-specific laws may come into play. If you've got an employee working remotely in another state, that state may have laws that are more restrictive than the federal law. Here in Texas, we basically follow the FLSA, the federal law, word for word. So no extra requirements there, but definitely look at it if somebody's working remotely from another state, or you've got somebody employed permanently in another state, they may not qualify for that computer employee exemption under state law as well. So I hope that's helpful. And if you guys have questions about, you know, what jobs may or may not qualify for the overtime exemption, feel free to ask them.
Thanks, Kevin. What I'm hearing you say is, you know, not only is there that first salary threshold, but in addition to that, it doesn't even matter what the job title an individual employee might have. What really matters is what that individual is doing on a day-to-day basis. Right. Okay, great. Thanks, Kevin. The next question I have is for you, Albert. Do employers automatically own all copyrights to any software created by an employee?
Thank you, Sonia. It's not automatic, but software creation by an employee or software development by an employee is typically the safest way to vest authorship and ownership rights of the software in the company. So let me take a step back here, because software or copyright is the primary form of intellectual property that protects software. And copyright can have, or has, counterintuitive notions of ownership and authorship. It's important for you all to remember, understand that under copyright law, whoever creates the software, the individual who creates that software is considered the author and owner of that software. That's the general rule. So if you want to have that ownership vest in the company, then you need to come under an exception to that general rule. And there is one under federal copyright law called the employee work for hire exception. The employee work for hire exception is important because what it says is that anything that employee creates or develops as a developer, as a software developer, will vest in the company. And the company needs those copyright rights, because those rights include the right to copy the software, make copies of it to sell, to distribute the software, be it web-based or server-based, or just basically to license it to customers, to make derivative works from it, to create new versions of it and build upon it, and also to display it. So, I mean, there's a whole bundle of rights that go with that copyright ownership that are essential for the company to possess if they're going to monetize their product, attract investors, create a customer base. So what do you have to do? Let's step back into the question now. What do we have to do to make sure that when our employees create something that the company owns it? And the first thing is, and let's assume that there was no contract. And I think that's a very common scenario right now because of the havoc that the coronavirus has wreaked on our economy. People are moving around a lot, especially in tech, and people are getting hired quickly, and maybe the onboarding process may not be as efficient and comprehensive as it used to be. Plus, a lot of things are happening remotely. They're not coming into, potential employees are not coming into the office to sign all the forms and hear all the understand all the policy manuals and having all that explained to them by an HR person or even the founders if you're working with just a very small startup. So it's important to get this right. And so, but let's assume that we don't have a contract, and you want to establish this exception. You would need to show that a work was created by this person, and that is a copyrightable work. That means that person didn't misappropriate it or copy it from somebody else. It's not open source software. They created an original work of authorship, and that person was an employee of the company. And we've heard Kevin talk about how you might establish who is an employee, or he will in the next talk. But the courts will look at how that person was paid. Did you withhold taxes or federal taxes from them? Did they receive benefits? Were they paid a salary? just general employee type prove up questions. So that's the second step. And the third is that the work was created within the scope of their employment. That is, they were hired to develop software. That was their job duties. They weren't an HR person who happened to kind of create a piece of code that the company used. So if you can establish those three things, then even without a contract under copyright law, that software ownership will be vested in the company. I think it's also useful to have software be developed by companies because, at least in Texas, employees are subject to some common law duties toward their employers. That is, they have what's considered a general duty of loyalty to not misappropriate trade secrets for their own benefit or disclose them to competitors, to not misuse company confidential information, to not compete against the company while they're working for the company. So by using an employee, you get the benefit of those what are called common law duties, even without a contract. But I'm here to tell you, though, any IP lawyer, any tech transaction lawyer you talk to will tell you that you need to go belts and suspenders on this. You have to make sure and get this right at the outset, so that it's typical to have an employment contract, even with your employees, that's going to designate who that employee is, what their job duties are. That is, they're hired to develop software, also to prove up the exemption, as Kevin discussed earlier, but also to have in writing that the employee signs that the work that they create is a work for hire under the U.S. Copyright Act. And even if it isn't a work for hire, if for some reason we don't fall within that exception, that employee assigns all intellectual property rights in that software, patent rights, copyright rights, trade secret rights, all of those rights to the employer, and that is an assignment that is in effect from the outset of the arrangement. You can also place, so that there's no question on that issue. You can also place more stringent confidentiality and non-disclosure obligations on the employee in that employment contract, as well as addressed other instances of employee behavior that you might have with respect to work from home. So the advice here is to not rely simply on the statutory exception, but to also formalize ownership in a written contract. Sonia?
Thanks, Albert. So from what I understand from what you just said is an employer has the burden to prove either by contract or through the list of factors that you provided that the employee's software creation was developed for the employer, and that burden sticks with the employer. And so would you agree that the best practice would be to have that contract, or in your experience, is it pretty easy either way?
The best practice is to have that contract. And I know that you and Kevin are very good and capable at providing companies with somewhat form employment agreements that can be customized for each employee, but they contain these pre-invention assignment terms, confidentiality terms, perhaps non-compete terms, so that that is dealt with at the beginning, and you can fall within the exception.
Thanks, Albert. I appreciate that further explanation. Kevin, the next question's for you. What about software developers who are classified as independent contractors? When might this be appropriate?
Well, sometimes it's appropriate. And this is another really tricky issue, I think, Sonia. And I do see this oftentimes with tech and startup clients. Classifying people as 1099 instead of W-2 or independent contractor instead of employee has become much more prevalent recently with kind of the explosion of the gig economy. You'll see Uber, DoorDash, those types of companies they don't have employees who are driving for them. They, are independent contractors. And there's been tons of legal fights here in Texas, out in California, elsewhere, where, the worker says, look, they call me an independent contractor, but I don't work for anybody else. I work for them. I'm really their employee. And, the companies come back and say, no, that's not true. They're not our employee. Look, they signed this independent contractor agreement. And, we don't control when they work, how they work, that sort of thing. This has really become, I feel like I get a question about this, 2 or 3 times a week these days. Can we call somebody an independent contractor, or, must we call them an employee? And, like Albert was talking about, an employment agreement or an independent contractor agreement in this situation can be helpful in, making sure that you've got somebody classified appropriately, because you'll have various recitals in there that, talk about who's going to do what with regard to the relationship. But just having an independent contractor, agreement, that's not dispositive. The courts, the Department of Labor, they're really going to look at who has control in the situation. Is the putative employer or the company, are they controlling how and when and why the employee does things, or the potential employee does things a certain way? Like that, the overtime exemption that we talked about earlier, this one's really important as well, because if you get it wrong, if you misclassify somebody as a 1099 when they really should have been a W-2, they can file a lawsuit against you under the FLSA. And what they would try to recover is basically all the wages they would have been paid if they were an employee. Let's say in your independent contractor agreement, you say you're going to pay a software developer $50 an hour. And that software developer is, working 50, 60 hours a week. If you misclassify them, that developer is going to come back and say, look, I should have been paid as an employee. I was paid by the hour. They're going to try to argue that no exemption applies, and that, those 50 and 60 hours a week, you all of a sudden owe me overtime for every hour over 40 in a week that I've worked. The employee could get, liquidated damages on top of that. In terms of the amount of wages they should have been paid. They're going to argue they should have been provided benefits like any other employee. But where these cases get really dangerous, and why plaintiff side employee lawyers like them, it's sort of become a cottage industry all over the nation. They can get their attorney's fees when they file these sort of lawsuits. So even though you may have an employee that, let's say, was only owed a couple $1,000 in overtime, the lawyer is going to file a lawsuit, and lawsuits are expensive, and you're going to spend $150,000 in attorney's fees on a case. It's really not worth that much. And on top of that, these cases have class action potential. If you have a wide variety of folks who have been misclassified as independent contractors instead of employees, all it takes is one person for a lawyer to sign them up as a plaintiff. They file the lawsuit, and they're going to say, I'm suing now on my own behalf and on behalf of everybody similarly situated to me. So every employee in the company that's a software developer, they're going to have the same claims against you, whether they want to bring them or not. They're going to have the opportunity to. So it really, like I said, boils down, the classification issue boils down to control. In Texas, the courts have this 5-factor test that really looks at the economic realities of the work relationship. How much control is exercised by the company? What is the worker putting in terms of an investment versus what is the company putting in? Who's buying the equipment? If you're providing computers and office space and internet and everything else to these folks, and they're not really providing anything on their own, the court's going to say, well, that looks much more like an employee situation than a contractor situation. Does the worker have individual opportunity for profit and loss? There's an interesting case out of the Fifth Circuit Court of Appeals this past year, which is the federal court that covers Texas. And it was actually for a drilling company, but they had these drilling consultants who use software and a bunch of other stuff to try to figure out where to drill these oil wells. And the company admitted look, we have some of them that are classified as employees. We have some of them that are classified as 1099s. And the only difference between the two, they do exactly the same job. But the only difference between the two is that the 1099s, if we call them up and they're busy or they don't have time to work on a project, they can turn the work down. And they also had the opportunity to sort of negotiate an individual or a piecemeal rate for each project that they were asked to work on. Whereas the employees couldn't turn down work. They had a set rate they were paid no matter what. The Court of Appeal, or the trial court here in Austin actually said that, look, that sounds a lot like an employee to me. If they're doing the exact same thing as these other employees, why would you consider them 1099s? And the Fifth Circuit came back and said, well, no, we disagree. We think, the fact that they have the opportunity to turn down work, the fact that they, can be paid differently based on, their negotiations, that gives them, individual opportunity for profit and loss. It gives them more control over the situation. So pretty employer favorable result, I thought. It was a little bit of a stretch in my mind, but that's what the Fifth Circuit came out with. So, there's always gray around this. There's never any sort of black and white answer. It really boils down to the economic realities of the situation. Is the person in business for themselves? Are they in business, with the employer? If a software developer is only working for you, you're their only client as an independent contractor. If you all of a sudden decide to terminate the relationship and they don't have anything else to do, they're reliant on you for that work. That's probably a lot more akin to an employee relationship. But if it's the opposite, where you hire the software developer to write code for this app, and he or she's doing that for a variety of other clients that he or she has, that's probably a lot more like an independent contractor relationship. So I hope that's helpful. This is definitely a complicated issue.
Yeah, it definitely sounds like it, Kevin. And so for our audience members who are starting up, their new businesses, they might start thinking, well, if I classify the software developer as an independent contractor, then I don't have to pay them overtime. I don't have to worry about providing them benefits. But it sounds like from what you're saying is it's best to analyze each individual and make sure that they truly are an independent contractor, because otherwise they can find themselves owing attorney's fees and other statutory violations if the Department of Labor determines that they were misclassifying employees.
That's exactly right. And one thing I left off, it's not just the Department of Labor. So if the Department of Labor comes calling and they say, hey, you got this wrong, I can guarantee you they're going to go talk to their buddies at the IRS, and the IRS is going to come back and say, yeah, all that money you paid that contractor, you should have been paying, FICA withholding and Social Security and all that on it. So it's not just the attorney's fees and the damages to the employee. You're going to have a tax problem too.
Great. Thanks, Kevin. The next question is for you, Albert. How are the IP ownership rules different for works created by an independent contractor?
Thank you, Sonia. Yeah, they are different. And in fact, I would venture to say so much code now is being done by independent contractors that this is a real, this is to me the main takeaway from this talk from my perspective, because as said, given the economy, people are doing more freelance, people are doing more consulting, and people have extra time. They're working from home and they want to make extra money. So, but the rules are different. And remember how I said under the employee work for hire doctrine, that could apply even without a written agreement. But for the independent contractor, you must have a written agreement in order to come under an exception, come under the work for hire exception for an independent contractor. So to me, it's fundamental for any onboarding by any startup, for an independent contractor, is to have a written agreement before they do any work that they sign that has these critical terms I'm going to discuss here. And I know it's hard to do virtually. It was a lot easier when people could come into the office and have a real sit down onboarding meeting. Now you've got to email forms. You got to get signed forms back. You've got to, keep those forms so that you can pull them up later on if you need to rely on them. But this is kind of the blocking and tackling that startups often make mistakes on, and I've seen it come back to haunt them in many ways. In another topic that we can talk about in a second. But with respect to a contractor, you need to work with your lawyer or develop a form and have your lawyer review it for you that applies for software developing. So that form would need to say that this contractor is being hired to do a specially commissioned work. That is, here is a project that we're asking that contractor to undertake. This is the deliverable that we expect from that contractor. So it looks like it's the copyright statute says a specifically commissioned work. It's not just ongoing, software development like you might have for an employee. This description of duties, contractor description of work should be different. Secondly, and this is not typically addressed in the contract, but that type of software must fit within 9 enumerated categories of works that the work for hire doctrine applies to. Software is not listed in one of those 9 categories. It's considered typically a literary work, and that is not one of the work for hire categories. But audiovisual works are in there, and sometimes they're classified as that. But even if it doesn't apply, you still want to be able to claim that the exception is going to apply in a different way also as well. But you want to say in that agreement with the contractor that you must use the words work for hire, that this work that we're doing is a work for hire under the U.S. Copyright Act, and anything that you make, contractor, is going to be owned by the employer or by the hiring party. So the contract, if it's also a well-written one, will also have an assignment of rights that says, even if this turns out to not be a piece of software covered by the work for hire exception for contractors, you have an assignment of rights, IP rights, copyright, patent rights from inception that are going to go belts and suspenders on ownership. Now, recall that if you don't have a good contractor agreement written, then even if you pay for the software, even if the developer gives it to you, even if you've been using it for several years, that contractor still has a claim as a co-owner or of the copyright that you used. You might have taken his code and combined it with a bunch of other pieces of code to create your product. He has a claim to the right to over your use of that software, and that can come back to haunt you. So get a well-written independent contractor agreement. Get with your attorney to have one that you can reuse and adapt. Put in there specific terms that don't apply to contractors, employment terms that don't apply to contractors. Remember, I talked about employees having a general duty of loyalty and all those other protective things. Contractors don't have those. Okay, there's nothing that says a contractor has to keep your information private or confidential information private. There's nothing that says that he can't use your trade secret or he can't learn things from your trade secret. And we can dispute over whether what you disclosed to him is a trade secret, but you have to know that they're kind of hired guns, right? They can go out and compete against you. They can go work for your competitor. So if you want to try to limit their ability to use things that you give them or things that they're building for you, you need to specify that in the agreement. So another thing to put in there is some elements that will show that that person is in fact a contractor. And you can put in there that, a specific clause that says contractor acknowledges that he or she is not an employee of the company. We're not withholding benefits. They're not entitled to vacation or overtime. You're being hired on a project basis and being compensated on a project basis. things that have a written record so that later on, if there is a Department of Labor audit, you can say, look, this contractor signed an agreement that says he wasn't an employee. So that's kind of on the employment issue, but primarily on the software ownership issue, you must have a good independent contractor agreement.
Thanks, Albert. I mean, and I think that this really teases out that it depends on every situation as to whether or not the independent contractor or the employee route will be best for your company. There's no one size fits all. There are pros and cons to both sides. So thanks for that insight. Kevin, the next question I have is for you. For folks looking to leave a corporate job or join or create a startup, what should they consider in terms of a non-compete?
Well, I guess it depends on if you're joining a startup or you're creating a startup. You might have a different opinion on what that non-compete should look like. I mean, if you're going to be an employee of a new startup, my guess is they're going to try to require you to sign a non-compete. And so under Texas law, at least, in order for a non-compete to be enforceable, you've got to be provided, this sort of confidential information, proprietary information, trade secrets that Albert's been talking about. Assuming that's the case, then what the courts look at to determine if a non-compete is enforceable is if it's reasonable. What is the scope of what it restricts? Where can the employee work? Where can the employee not work? How long is the non-compete? Those things all vary depending on, frankly, what the company is, what the startup, the project is. In terms of, let's give an example. I've seen non-competes sometimes that'll say something like, if you come to work for us, you sign this agreement, okay, for 24 months after you leave, for whatever reason, you can't work as a software developer in the United States. That's not enforceable. That's way too broad. It needs to be something more akin to, let's say, the startup is developing an app that, I don't know, lets you talk to your pet or something while you're outside the house, kind of a cool idea. And there may be something out there like that already. I don't know. But the non-compete in that situation, if I'm representing the employee, I'm going to say, no, the non-compete needs to say this employee cannot go work for a business that is creating apps, that involve, I don't know, communication with pets over the internet, or something like real narrow like that. You want to focus on a shorter time length. 24 months used to be sort of the standard. I've seen it's more trending toward 12 months now, at least in Texas. Not saying 24 months can't be enforceable, but courts are going to look at the situation. Why do you need a 24-month non-compete instead of a 6-month or a 12-month? Is that how long it takes you to get this app to market? So you have a legitimate reason to keep this person out of a competitive venture for 24 months. The territory, usually in the past, you'd put some sort of geographic, radius around, what territory the employee couldn't work in. That's sort of gone out the window these days, especially in this space. Everybody's working remotely, or people, you may hire an independent contractor in Seattle to do work for you in Texas. So it wouldn't make sense to say they can only work, they can't work within 50 miles of Austin in this space. No, I mean, it should be, they can't work in this very narrow space altogether, hopefully. That's going to be more reasonable in terms of, enforceability. So if you're on the other side and you're the employer having somebody sign a non-compete, obviously you want it to be more all-encompassing, but, be careful what you wish for, because if you make it too broad, it's not going to be enforced. You'll have to go to court and get it reformed. It costs a bunch of time and money. So it's really better to, make it as narrow and as reasonable as you can on the front end. That way you don't have to have that fight on the back end.
Great. Thanks, Kevin. We got a question for the audience. It's a quick one, so I can just go ahead and answer it. Do you all have a simple independent contract agreement? And I think we can all say yes, we do. We have independent contractor agreements that range for startups that have employees or independent contractors in one state or multiple states. So the next question I have is for you, Albert. What can employers or the hiring party of a contractor do to fix copyright ownership issues? I think you're on mute.
Thank you. This is the situation that you don't want to be in. That is, you might be getting ready for another venture capital round, or you might be looking to look at a potential sale of the company. And in doing that, the VC or the buyers are going to go through what's called the due diligence phase, where they look through your records and see how solid your ownership claim is to your IP, looking at your finances and other things. But we're talking about ownership of IP here, so they're gonna typically look at a roster of your employees to see who has worked on the code, who has done inventing for the company, and they're going to do a cross-reference to see, okay, are there agreements in writing from those folks, assigning all of their rights. So you need to understand that's going to eventually happen. So ideally, if you find that you have a gap, you had an independent contractor that you didn't have a good agreement with, or there may be an issue with the employee who did the software developing. Ideally, they're still working with you. You can get them to sign one, present them with one, and kind of they agree that everything they have created for you in the past and in the future is going to be owned by the company. But if you're in a bad situation where that employee is left or is disgruntled, the independent contractor has gone and moved on, you're going to have to chase him down and get that gap filled. And you might have to purchase, you may have to pay them additional money for that assignment. They may realize they have a lot of leverage over you. So, but it's going to be essential for you to do in order for you to be able to sell or get that next round of financing. One other question that I saw was about what happens if the employee develops software on their own. That happens quite a bit. A lot. It can be very fact specific. If it's related to what the employee is making for the company, I think the employer has a strong argument that what they did is kind of a derivative work or based on what they had they're making for the company. If it's outside the realm of what the company is doing, it's a different type of app, different type of industry, the employee has a better claim that it's not covered by the scope of his duties to the employer. There was one other question on the do I need a new independent contractor agreement every time I do a new project for the contractor? And my answer is no. Ideally, with your well-written independent contractor agreement, it'll kind of be kind of a master agreement. It's going to cover multiple projects, so that you can have one project and then you can create another work order and say it's subject to the terms of that master services agreement that we signed, a year and a half ago, and it incorporates those terms. And so that you don't have to be recreating a new contract every single time. But it is important, I think, for them, when you do a new work order, for the contractor to sign that work order and to identify the contractors that they are going to have to work on it, just so that as well.
I'll add one piece there, Albert, just at the end. So one thing that I often see clients do, and it's exactly what you're saying, is they have a sort of overarching contract and an addendum or a scope for each project. I've seen folks try to get around the employee classification issue by saying, we're just going to assign this person a new project every 3 months. Again, you got to look at the overall situation. You can't just call somebody an independent contractor if everything they're doing is just for you. But if they've got contracts with others and you're repeatedly using them for separate standalone projects, that classification is probably okay. But don't try to contract around the employee issue by just having standalone 3-month projects here and there where really the person's just working for you.
All right. Thank you so much, Kevin and Albert, both of you, for your great insight for our audience.
Thank you, guys.
Thank you all, Hush Blackwell team. Incredible work. Thank you for the advice. This is really actionable work. And folks, find them at their website or find them on LinkedIn. This is a great legal team to have on your side. Startups need lawyers. We need good, timely advice. So it's incredible to have you here, and we're really thankful for you sharing and giving to the community today.